Good morning, everybody. And as always, thank you for joining us today. We have a number of updates we want to get right into, so we have enough time for our main presenters as well. We'll start right in with Dr. Pinsky.
Thank you, Errol. Very brief update. Our positivity rate is 4.4%, 7-day positivity rate, which is very similar to what we've been seeing over the last several weeks. As you can see from the variant data, we are essentially all Delta over 95% of cases. And that's my update for this week. Thank you.
Thanks so much, Dr. Pinsky, and always for helping with any questions that may pop up. Next, we'll move to Dr. Paul Heidenreich to give us update from the VA.
Thank you. So briefly from the VA, we've had fairly stable inpatient admissions for COVID between 1 and 6. Our employees, though, we've seen a slow, steady trend in overall positivity. You can see here out of 5,000 employees, still the rate is pretty low, but it has continued to inch up. As with what Brian said, about 70 to 80% are breakthrough infections, although very few of those have actually been hospitalized. So I'll stop there. Thank you, guys.
Thanks as always, Dr. Heidenreich, for being with us as well. So thank you for all our panelists who are providing updates. And as you do have questions, thanks in advance for helping answer those questions related to those updates. So next week, we'll be kicking off Women in Medicine Month with Dr. Arga Gonzalez with the presentation from Cuomo to Healthcare, Sexual Harassment in the Modern Era. I want to make an announcement. We were initially planning to do our first in-person / Zoom medical grand rounds, but we decided recently, given likely what would be most people joining on Zoom right now, that it probably made more sense to just stick with Zoom for now. So we're going to keep that fully on Zoom until further notice. We're still tentatively planning to our first date in October to be in person. We'll kind of play that by ear depending on how things are at that point. So just a reminder, we won't be doing this in person next week. So please keep joining online like you're doing. And thanks for joining. The week after that, we have Dr. Molly Carnes talking about bias as a habit that can be broken. And then the week after that, transgender adults in clinical medicine. So we have a lot of great topics coming up in September, and we hope you stick with us. Today, we have a very great and important topic that I think has been on a lot of people's minds, probably often in the past year and a half, particularly all our clinicians. We have doctors Michelle Mello and David Studdert who are with us. Dr. Studdert and Mello are both professors in law school in the Center of Health Policy, Primary Care, and Outcomes Research, and also professors of medicine within the School of Medicine. But I do want to note, I think many of you know that our division of health policy and primary care and outcomes research is soon to become a department, and Dr. Doug Owens will be leading that. So we're really happy to see that happen, and that should be happening very soon. So especially this is one of the last official things that Drs. Mello and Studdert will be with us as official professors of medicine. So thank you for being with us today. Both doctors hold doctoral degrees in health policy as well as law degrees. They've worked together for more than 20 years on issues in the intersection of health law, health policy, and bioethics. Their research involves empirical investigations as well as legal and ethical analyses. During COVID-19, they examined issues related to individual rights, public health orders, state and federal public health powers, digital contact tracing, artificial intelligence, predictive modeling, hospital triage policy, vaccination policy, school reopening policy, and many, many other issues. Many articles you may have read throughout the year and a half, oftentimes they are being quoted in it or involved in it in some way or another. Professor Studdert has also been involved with empirical work modeling for COVID burden and vaccine acceptance and effectiveness in California prisons. I could go on extensively talking about all the different things they've done over the many, many years, from number of hundreds of articles they've been part of, and just so much of the work they've done. I always want to comment for years, since we've had the communications team since in the last 8-9 years, Dr. Owens has always continually let us know all the amazing stuff that his colleagues do. And I've been learning all the great stuff just from Dr. Owens alone, from both Drs. Mello and Dr. Studdert. I remember I was actually looking through a lot of my old emails and remembering all the amazing stuff that we knew specifically about both of you, Drs. Mello and Studdert. You sat on, Dr. Mello sat on a committee at the National Academy of Sciences, Engineering and Medicine. She looked at ways to tackle high cost prescription drugs. Dr. Studdert, who did years-long study using handguns, found that owning a handgun dramatically increased risk of higher suicide. And of course, with COVID-19, endless number of aspects you guys have been involved with. It's been extremely valuable. So you guys have been doing amazing work for many, many, many years. And this work you've been doing in the pandemic is just another example of that. Thank you for being with us today. I'm going to turn it over to Dr. Mello to first for some opening remarks. Today's conversation is just that. It's a conversation without slides. We have a lot of questions that Drs. Mello and Studdert helped us put together that we're going to start that dialogue off. I do want to encourage you to start asking questions. We will hold off on getting to those questions once we pass the first phase of this conversation, but please do ask those questions, vote them, so we have those to get going as soon as we get started. I'm sure there'll be many of them. So Dr. Mello, thank you for being with us today. I'll turn it over to you first.
Thanks so much. Let me begin with a CME disclosure, which is that I serve as an advisor to Verily Life Sciences on an app designed to facilitate the safe return to work and school during COVID. I thought we would begin with just a very short overview of how public health law gets done in the US as a way of setting the frame for some of the specific legal disputes that we're going to be talking about. I want to focus, though, our discussion on 4 hot questions that are percolating in the courts right now. As you are all aware, there have been literally hundreds, probably over 1,000 different lawsuits filed during COVID over various kinds of public health mitigation orders. We're just going to focus on those that are really active at this point in time, but we're happy to take questions about some of the earlier ones, for example, relating to cities and states stay-at-home orders. But before we get there, let me just sort of overview what those topics are going to be. First, we're going to ask the question whether states and local governments can require vaccinations. Can employers do so? What are the legal boundaries around that? Secondly, can a school district require their students to wear masks when the governor says the school district can't do that? Very hot topic in the news right now. Third, how broad is the authority of the CDC to issue actual orders to stem the spread of COVID? Most people think it's pretty broad. Legal scholars don't always agree. And finally, will health officers in the future have the same scope of legal powers that they have had during COVID? So all of these disputes raise pretty core questions about who gets to make what kinds of public laws in this country and what sorts of rights and authorities serve as counterweights to what health officials and legislative bodies are trying to do in this space. Historically, public health law in the United States has been overwhelmingly a matter of state law. And that's a matter of constitutional design, because our Constitution gives states what judges call a police power. It doesn't have anything to do with law enforcement, but it refers to the broad authority of state governments to pass health laws of every description that promote the state's interest in having healthy and safe citizens. They can delegate that power down to local governments, but they have it and the federal government does not. The federal government, in contrast, is limited to doing things that it can tie to a specific jurisdictional hook in the Constitution. The Constitution lays out certain enumerated powers for the feds, and they have to make the argument that what they want to do fits within one of those enumerated powers. For our purposes, there are 2 that are most important. One is the power to regulate interstate commerce. So anytime goods or people are flowing over borders, state or national, the government can make the argument that they can regulate in ways that affect interstate commerce. And the second important power is the spending power. When Congress appropriates money, it can attach conditions to the expenditure of that money that affect what states can do. There are limits. We learned when Congress passed the Affordable Care Act, it can't give states a kind of nuclear option, either, implement this program that we want you to do, or you get no more Medicaid money. But historically, that's been a pretty broad power as well. So the federal government can do things in certain domains, but generally when we're talking about public health law, we're talking about state and local law. even though those units of government have really broad powers, there are some limits, as you know. One of them is constitutional rights. Individuals and businesses have certain individual rights protected by the Constitution, like freedom of religion, freedom of speech, freedom from interference with more general liberties, anti-discrimination protections that limit what all kinds of government can do. Second, there are constitutional provisions that limit a state's ability to regulate beyond its borders. So again, interstate commerce, that's a federal power. States are supposed to only do things that affect their state residents, businesses, affairs, and only incidentally kind of affect interstate commerce. And third, state and local laws under certain circumstances can be preempted by federal laws, meaning there are a few areas where courts have recognized all of these actors have the authority to regulate. And if the federal government comes in and says, look, we want to do it this way, inferior units of government can't override that. And then within states, there are also battles about whether local governments can override the views and policies of state governments, which I'll talk about later. So this is how power is divided between the national, federal, and the state and local governments. There is also a division of power between the branches of government, the courts, executive agencies like the CDC or the State Department of Health, and legislative bodies like city councils, school boards, and the Congress. To ensure that executive officials like governors are adequately empowered during emergencies, Congress has kind of beefed up what they get to do during times of declared emergencies like the one that we're living under now. It has passed special emergency powers statutes that expand their everyday powers and give them authority to do things without involving the legislature. And to make sure that they don't overstep in doing so, there are a few limits on emergency powers. The most important one is that they're time limited. As we all know, emergency orders in the counties have been re-upped over and over again after a period of time has elapsed, and that is by design. A lot of these laws also establish formal procedures that agencies have to go to if they're going to issue certain kinds of regulations that rise to the level of a rule. They're supposed to allow for a period of public notice and comment about what they want to do, and then they're supposed to consider the public's comments and then revise in light of that. And that's only if they're issuing a formal rule. Sometimes they can do things during emergencies without having to do that, but they still have to stick to other procedures. During and outside emergencies, both agencies can't act in ways that are arbitrary and capricious. They can't be completely unreasonable. They have to articulate a basis for what they're doing. And again, they have to follow certain procedural rules when they're taking some kinds of administrative action. And then finally, like statutes, agency actions can't trespass on constitutionally protected rights. So how do these limits get implemented? Well, courts get asked to review actions taken by legislative and executive bodies. And these are brought by people who have a live injury. Something has actually happened to harm them in a way that courts recognize. And the courts are asked to decide whether the government has overstepped its statutory or constitutional powers. The important thing to know is that historically, courts have been really deferential to actors at the state, local, and federal levels when they are taking steps to protect the public health, and especially when they're combating infectious diseases, and double especially when they're doing so in the context of a real live emergency. So going into the pandemic, everybody just kind of thought, look, this is going to be a no-brainer when people are challenging these orders. The courts are simply going to say, look, is it reasonable? Was it in furtherance of a legitimate state interest? Well, if so, it's really not our business as a court to second guess what health officials are trying to do. In reality, the landscape has been much more complicated, and it continues to be so. So I will pause there and turn it back over to you for discussion of our first topic.
Dr. Mello, thanks for that introduction. And again, I just want to make a brief announcement, particularly for those who have just joined. We're doing for the first half here, a conversation, no slides. Please ask your questions in there, and we'll get to them during the second part of this, and please vote on those questions so we can triage the ones that are most important to you. I want to open up with talking about vaccine mandates. Perhaps Dr. Studdert, I'll engage you on this. We've seen the healthcare systems across the country, including the VA, mandate vaccinations for healthcare workers. A number of organizations, colleges, employers, restaurants, bar, sports, airlines, and entertainment venues introducing vaccine mandates pretty quickly. Are these vaccine mandates lawful?
Yeah, question of the day, right, Errol? The short answer is yes. they are lawful. But you know that a lawyer is not going to be able to stop there. So I want to take you through a few scenarios and talk about some of the circumstances under which that might be tested. They're lawful according to long-standing public health law precedent, as Michelle mentioned, so long as the threat is real and they're a legitimate attempt to combat that threat, these kinds of interventions are going to be lawful. And they're also lawful according to several federal guidances that have helpfully been issued out of Washington over the last 9 months that have specifically said vaccine mandates are okay in designated circumstances. So one of those circumstances is the employment context. The guidances have said that it's okay to ask employees to show proof of vaccination as a condition of showing up for work. If employees can't or won't show that proof, then an employer may need to look at providing some kind of accommodation, such as allowing them to work from home, but the employer is not bound to give them a pass in every case. Indeed, some employers in high-risk employment settings, such as factories or even healthcare settings, may be required to implement programs like this as part of their obligation to provide a safe workplace. Colleges and K-12 schools are another setting, both public and private. We know that they have a long history of requiring proof of certain kinds of vaccinations as a condition of entry. Adding COVID-19 to that list, it's not going to be legally problematic. And in a recent challenge to Indiana University's vaccine mandate for students, the Seventh Circuit Court of Appeals said exactly that. But I want to pause and just say that language matters here, and the word mandate is used very broadly at the moment, and I think in many cases inappropriately, because it doesn't actually match many of the programs that we're talking about. I think it's more accurate to characterize these programs as incentive programs in many cases rather than mandates. To participate in the activity, you must either attest that you're vaccinated or submit to additional requirements. Usually those requirements are testing on a weekly or twice weekly basis and perhaps masking up. So those programs, again, I think it's the lion's share of them, are not what I would call a mandate. It's an incentive program that offers a more convenient pathway for the vaccinated. At least one court's recognized that distinction. A court in Southern California dismissed a claim against Los Angeles Unified School District in July. And the judge noted that this was an incentive program, not a mandate program, and treated it as such. I think we can expect many more rulings like that, indicating that there is a distinction between an all or nothing mandate, which does exist in some circumstances, most notably in healthcare settings, but not in the vast majority of circumstances.
Dr. Studdert, can I get you to talk a little about exemptions? What kind of exemptions does an employer, a restaurant have to make for people who refuse to get vaccinated or refuse to say whether they're vaccinated in the first place?
So medical exemptions are required by law. That's just clear. Employers have to offer reasonable accommodations to religious objectors, meaning that if there's an adjustment or an alternative that can be made without an undue hardship on the employer, then the business may need to provide that for people who have a sincerely held religious belief. For example, a clerk who normally works in a customer-facing role, but can't or won't be vaccinated because of religious belief reasons, the employer may need to look at putting them in the back room with some other kind of assignment and asking them to mask up. But again, this is not going to be a requirement for all employers in all cases. A respiratory therapist or a nurse whose job is patient care, that's going to be much tougher. And in those circumstances, courts may readily accept arguments that there just isn't a reasonable accommodation possible. Outside the employment context, religious exemptions aren't currently required as a matter of constitutional law, but that issue has never reached the higher courts. Legal scholars are actually debating this at the moment and wondering whether the new conservative majority in the Supreme Court may rule on this issue. But for COVID, nearly all of the mandates have sort of skirted this problem because they have allowed exemptions for medical and religious reasons. And of course, the vax or test incentive programs provide an out that doesn't implicate the need for these exemptions. When it comes to public spaces like restaurants and bars, again, very topical at the moment, given what San Francisco has done, we should distinguish between employees and customers. People have a right under federal anti-discrimination law to access public accommodations without discrimination on the basis of personal characteristics, religion, disability, pregnancy, age over 40, and so on. So in theory, restaurants ought to accommodate customers who have a disability that precludes vaccination or have a valid religious reason. But how can that be implemented practically? We don't really have a precedent for it, and it's going to be really interesting to watch how this unfolds. It's just not clear to me how the maitre d' at a restaurant is going to be able to verify the authenticity of a customer's exemption claim in real time. For that to work, we're going to need some kind of technology or QR code that we're not really seeing yet in the market. We are seeing some of that for vaccination, but not yet for exemptions. So in those circumstances where it's not possible to authenticate, it's probably the case that the restaurant can exclude. Again, the court might insist there's some sort of accommodation there, like accepting a negative test result, but the practicalities here are going to be really tough.
Can we talk a little bit more? Dr. Bowman talks weekly here about our exemptions. Do we have to worry about these programs though being discriminatory? We have a system in place to really look at who's just saying they do and who genuinely does have an exemption, but could it be problematic to people feel like they're discriminated against?
Yeah, I mean, there's some very unfortunate historical cases here stretching back to the 18th century in the United States, and I think it's an important concern. Using a vaccine incentive program as cover for discriminating against workers or customers or students because of some other characteristic that the discriminator cares about, this is just outright unethical. And if the characteristic is a legally protected one, like gender or race or disability, it might also be illegal. So state and federal authorities are going to have to police this, and I think that there are efforts at the moment to do that. But usually people who voice claims about discrimination are actually talking about discriminating against the unvaccinated because they're unvaccinated. And the simple fact is that claim, you're discriminating against me on the grounds that I'm unvaccinated, that's not really a thing in civil rights law. Private entities can do that. They just can. No shoe, no shirt, no shoes, no vax, no service. That's okay. The government has a few more hoops to jump through if it's going to administer this kind of a policy, but so long as it can show it has a reasonable basis for treating the unvaxxed differently, then it's going to be legally permissible. And as far as the legal tests go, you know, the threshold is really quite low. A reasonable basis is not a high standard to meet in court. When it comes to discrimination, though, I don't want to get unduly fixated on the legal aspects here. The big issues, there are big issues here, ethically and morally. It's impossible to ignore the fact that rates of vaccination are lower among minorities and among the poor. So if we're going to condition participation in public life on vaccination, that may well have a disproportionate impact on members of vulnerable groups. Again, we shouldn't expect that the courts are going to do a whole lot about that, but as an ethical matter, we ought to be conscious of it, and we ought to be aware of the fact that this may well compound disadvantage. And again, I think it's yet another reason that we should try to redouble efforts to get at the root of the problem of reticence in this area: medical mistrust, misinformation, a lot of the things that have been spoken about in these sessions over the last few months.
Dr. Studdert, the Pfizer vaccine, as all of us know, has just received FDA approval, with others to follow, including Moderna. How does this affect the incentive programs?
Well, I think the last couple of days have told us that, Errol. It seems to have been a kind of marker or line in the sand that the Pentagon and a wave of state governments and corporations were kind of waiting for. I guess one must assume that those entities were holding back out of concern, probably misplaced, I would say, that the EUA status of the vaccines meant that they couldn't insist on proof of coverage. The federal government, as I said, has tried to clarify that that's okay, that you can do that, but some of the more cautious lawyers out there were probably advising their clients that they should just wait for that full approval. So full approvals are going to make this issue moot. But I think another reason that businesses have been holding back here is fear of a backlash, and there have been some well-publicized incidents of that in New York and other places. As these incentive programs, though, become more common, there's going to be plenty of cover for businesses that want to take this step. And there may also be technology that makes it easier for them to do this.
Thanks, Dr. Studdert. I want to migrate over. We are undoubtedly going to come back to this topic of vaccines. Thank you for those of you who have been asking questions. We're going to get to those questions. Please continue to ask more questions. You can comment on the questions currently asked and vote the ones up that you want. So thanks for that. Dr. Mello, I want to move over and talk about mask mandates, another extremely important topic. We're hearing so much about people going to courts to challenge these mask mandates. What are the legal issues in these cases?
So the first set of challenges was actually brought by individuals who didn't want to wear a mask, and they were challenging the mask mandates themselves, and they were making arguments about their generally protected constitutional liberties. And to quote David, that's not a thing in civil rights law. The right not to wear a mask is not a legally cognizable right. And so again, all the government had to show in order to rebuff those challenges was that there was a reasonable basis and it was in furtherance of a legitimate state interest. No problem. But the new batch of challenges is different. What is being done here is state governments, governors, and in some cases legislatures coming in and saying through an act of law that local governments and school districts cannot impose mandates for masks. So the litigation is about whether the state can override a mask mandate issued at a subordinate level of government. 8 states now have adopted bans on mask mandates for schools. They do this in a variety of ways, some of which are very creative, like just attaching conditions to school budgets, some of which are more frontal, like an act of the legislature explicitly banning these things. And in some states, the orders go further. For example, Texas Governor Abbott's order prohibits mask mandates, not just in schools, but for any governmental entity, including cities and counties, except for certain carve-outs like certain healthcare facilities and prisons. So what are the legal issues raised in this flavor of case? Well, it varies because these are all issues of state law. But the litigation in Texas, I think, is a useful exemplar for what's going down here. Abbott implemented that order pursuant to the state's Disaster Act. That's one of those special emergency powers laws that I described earlier that activates a broader suite of powers for the governor. A legally important aspect of what Abbott did was that he suspended a bunch of state statutes that seemed to empower local governments to issue mask mandates. Now, emergency powers laws like the Disaster Act do give governors the power to suspend regulations and some kinds of statutes that have kind of a regulatory flavor. And the reason that they do that is to kind of clear the way for them to implement protective public health orders in a crisis. We're all familiar with this at the federal level because we had a bunch of nettlesome regulations relating to HIPAA and telehealth swept away so that we could care for a surge of patients during a crisis. So that's what it's supposed to do. It's not carte blanche for an executive official to just overrule acts of the legislature. So what's going on in the litigation is two things. One, claimants are saying, look, you're violating separation of powers. You're intruding into things that the legislature can do, and has done, and has the constitutional authority to do under our state constitution. And so in the Texas case, for example, the governor is effectively saying to counties in Texas, I'm going to make the rules for how your employees have to keep themselves safe on the job instead of letting counties regulate themselves. And there are similar claims to that in other states. For example, in Arkansas, in a case brought by the local school district, a federal district court there said that the state constitution's separation of power principles were violated by the governor's ban on mask mandates for school districts. That's a province of local government. And the second thing that's going on in this case is there are just fights about how we should interpret these emergency powers laws generally. They're supposed to empower not just the state government, but also local governments to act in the case of a pandemic or other health emergency. But here we have a governor coming in and undercutting the county's ability to do so, and undercutting it in a way, not that furthers like a more restrictive or more health promoting regulatory framework, but that is designed to protect the public health less. Right? So the irony is that Abbott is using his emergency powers to disrupt public health orders when the intent of emergency powers is to enable states to impose orders for the protection of public health in an emergency. And so interestingly, when you read how courts are thinking about these issues, the parties are using the same kind of rhetoric about overreach of government officials that people who were previously challenging mask mandates we're using, only now it's being deployed to challenge the governor saying you can't have a mask mandate. So like many aspects of COVID response, when it comes to this area, up is down. A more general question that hasn't been litigated yet, but that I think is going to occupy legal academics for a while, is whether governors can even do this as an exercise of the police power. Always, the police power has been understood as giving states the authority to pass health laws to promote public health and safety. Now it's being deployed by these Republican governors to pass laws to undermine public health and safety in furtherance of some other political agenda that doesn't have to do with public health. It has to do rather with some conception of liberty or the role of government. So is that even a valid exercise of the police power? Surprisingly to me, none of the litigants have raised this that I'm aware of in litigation so far. But it's a really novel question. It's really rare that governments use their police power to do things that undermine public health. The last case I can think of where this happened was way back in the early 19th century when San Francisco, during a bubonic plague outbreak, just put a barbed wire fence around Chinatown, confining people who had plague, had been exposed to plague, and had not been exposed to plague all together in this concentrated area for an extended period of time. And the court said, quite rightly, this is completely irrational from a public health perspective. You're elevating risk here, and you can't do that as an exercise of the police power. But literally in all of public health law, there's no other case I know of where the government has tried to use its police power to undermine goals in furtherance of some other objective. In the Chinese case, it was anti-Asian sentiment, which was really rampant in San Francisco at the time.
Dr. Mello, so when talking about these cases where you have the state trying to control localities, what happens? How does this play out?
Yeah, I think some of these disputes may go away without the court's intervention because the governors are really in a tough spot. Arkansas's Governor Hutchinson has already said he regrets signing the legislation to impose the ban on mask mandates. He can't overturn it. I don't think the legislature will overturn it, but he could direct his attorney general just not to enforce it. Texas has already said it's going to at least temporarily stop enforcing its mask mandate ban against school districts while this litigation's pending. And Florida, as you're probably reading, is having a very tough time enforcing its bans. The school districts are just openly defying it. They are trying to yank salary funding for education officials who adopt mask mandates, but the Biden administration has come in and said, don't worry, we'll pay you. So there aren't a lot of levers there, and I suspect some of the governors will just kind of back away from it. It's harder to predict what will happen in court, in part because they turn on these very narrow issues of state law, and it's different from state to state. I can say two things. One, this is not going to be a matter for the U.S. Supreme Court, because these are matters of state law. The state Supreme Courts are going to decide them. And second, I do think some of these mask mandate bans are vulnerable. Some of them are written really sloppily. They don't reach some settings like private schools, and that undermines the government's ability to make the case that it's furthering some important state interest when it doesn't go far enough. Some of them really do seem to intrude into areas that are the province of local control. So I think if we get to that point, some of them will fall.
Dr. Mello, can I ask, does it make sense for the Biden administration just to limit this whole problem with a federal mask mandate?
Yeah. Well, whether or not that makes sense as a policy matter or is even politically possible, I think legal scholars generally agree it's not legally possible. And that's because of what we talked about at the beginning of the session about how the federal government is limited in the areas that it can regulate. It doesn't have a federal police power, so it's not in a position to say to every man, woman, and child, you need to wear a mask. It would have to be able to make the case, for example, that the setting where the mask was required had something to do with interstate commerce. And that's easy to do for airplanes and trains, but it doesn't generally apply to a person just existing in public and not wearing a mask. It could try also to tie mask mandates to some spending. That seems possible for some settings, including schools, but it's not going to reach, again, every man on the street.
Great. And Dr. Mello, I'd like to transition over to now the topic of the CDC's authority and how they've been imposing many of these orders. We've all been following it very, very closely, the evolving guidance of their mitigation measures. And many of these guidance are described as recommendations as opposed to mandates. What kind of orders related to the CDC and regarding COVID what are these orders? And really more importantly, what gives the CDC the power to implement these orders / recommendations?
Yeah, so we do mostly think about the CDC as doing two things. One is issuing recommendations for how we should all conduct ourselves. And then the second is when you've got an individual who's got a disease, or we think they've got a disease that's infectious, CDC can quarantine or isolate them. And that goes also for international travelers who we suspect are at risk of having a communicable disease. But during COVID, including during the Trump administration, the CDC actually took some pretty strong and unprecedented steps to issue other kinds of novel orders. I'll talk about two of them just briefly. One is the eviction moratorium. It said that landlords on a temporary basis cannot evict people for non-payment of rent. People still have to pay rent eventually, but you can't kick them out right now. And the second is the Healthy Sail Program, sometimes called the Conditional Sailing Order, which is an attempt to get the cruise ship industry up and running again. In order to get up and running and get a permit, they have to show that they've met a bunch of really quite burdensome and unprecedented requirements, things like building shipboard labs and doing test sails and demonstrating they can keep their passengers safe, unless they can show that all their passengers are vaccinated. So those might seem like kind of narrow things, but they're really important because they are testing a crucial legal issue, which is how broad is the CDC's quarantine authority under something called the Public Health Services Act. That authority exists because of CDC's power to regulate interstate commerce. And the act basically empowers CDC to make regulations that, in its judgment, are necessary to prevent the introduction, transmission, or spread of communicable diseases. But what's tricky and somewhat unfortunate is that the act then goes on to list a number of specific things that the CDC can do to carry out that kind of regulation. And they're things like inspection, fumigation, disinfection, pest extermination, and destruction of animals. And so what has happened in this litigation is that the cruise ship industry and landlords have filed cases saying, look, this is a far cry from fumigation. The CDC is issuing these sweeping policy orders and trying to pin it on a statutory authority that's meant to be much narrower.
These orders seem novel, but certainly within the wheelhouse of things that might help prevent COVID, that it makes sense. But there's been this, so why is there an argument about whether they're within CDC's authority in the first place?
Yeah, it really has to do with how these two different groups of people are reading this statute. CDC, on the one hand, is focusing on the part of the statute that gives it broad authority to enact regulations that, in its judgment, are necessary to prevent the spread of communicable disease. And they're reasoning along these lines. Well, number one, cruise ships are huge vectors of transmission. We know that, little argument there. And with regard to evictions, well, when people get evicted, they're more likely to end up in homeless shelters and other congregate settings, or to stuff in with family and friends, and that increases the risk of COVID transmission. And now CDC was actually able to cite a recently published study showing that after states lifted their moratoria on evictions, both COVID incidence and COVID mortality went up significantly. So it views these both as measures that are reasonably related to COVID control. Now, the plaintiffs, on the other hand, say, look, quarantine means quarantine. This, throughout our history, has been limited to things that are targeted at infectious animals, things, and people, and confining them until they're no longer dangerous. And what CDC is doing here is very, very different. And there is like no stopping point. If these things are allowed, CDC de facto becomes a policymaking body on a huge range of issues.
What have these courts done so far in these cases?
Well, it's all over the map. There have been several different courts that have considered the eviction moratorium. They have reached different judgments about whether CDC can do this. In June, the US Supreme Court, by a vote of 5-4, voted to let the CDC's eviction moratorium stand. But one of the justices, Justice Kavanaugh, said, look, I'm only doing this because it's going to expire at the end of July. Well, what do you think happened? End of July rolled around, it was renewed. So we now have it in a slightly more targeted way until October. Predictably, there now has been a new round of legal challenges filed. It's not clear whether the Supreme Court's going to take that case again, but if it does, all indications are that it will strike down the moratorium just based on how the justices align themselves the first time around. So far, most of the lower courts have declined to block the order, but again, there's a split. And whenever lower courts disagree about something, the Supreme Court likes to jump in and resolve that. With regard to the cruise ships, so far, the cruise ship lines have prevailed in the lower court, but the litigation is still in a pretty early stage. When I've read these opinions that have basically been asking for emergency orders to block this from going into effect, all the judges, though, seem very leery of the kinds of arguments that CDC is making.
Great. And I'd like to move on now, talk a little about the legislative moves against public health powers. Dr. Studdert, nearly every state is considering bills that would limit the power of the governor or public health officials. Some states have already enacted them. Where is this movement coming from? You're still on mute.
Yeah, thanks. It's mostly coming from anger, Errol, from a perception that over the last 17 months, public health officials have been out of control and wielded way too much power, from the shutdowns to the gatherings being limited and masks, and of course, most recently by these vaccine requirements that are creeping in. So there's a segment of the community that thinks about this as massive overreach by unelected officials, and there's a backlash playing out. Now, the extreme end of that backlash is the frightening behavior that we've all been reading about, which involves harassment of public health officials and in some cases, threats, physical threats to them and their families. This wave of laws to reduce or water down public health powers is obviously a long way from that sort of behavior, but it comes from a similar place, which is that there's just too much intrusion and unaccountable power here. I should also point out that the effort in the state legislatures to undo public health powers is really being very well coordinated. There's an influential nonprofit organization devoted to conservative lawmaking that's been around for a long time called the American Legislative Exchange Council, funded by corporations and trade organizations. And ALEC, so-called ALEC, has been coordinating these legislative moves, right down to providing model language that tends to go verbatim into these bills.
And I want to skip to this question. It seems like public health officers have extraordinarily far-reaching powers during the pandemic. Should we welcome these moves?
Well, it's a good question. The powers that we vest in public health authorities come from a combination of police powers, traditional police powers that Michelle talked about, and also these emergency powers statutes that were enacted after 9/11 to deal with security threats and natural disasters mostly. These laws weren't really built with this kind of unprecedented pandemic in mind, and they've been stretched and tested in ways that I think nobody expected. I think there is a good case for revisiting the legal framework we have for dealing with pandemics, but how we do that matters. It shouldn't be done really quickly. It shouldn't be done in a partisan way, and it shouldn't be done in a process that's dominated by people that have been hostile to public health powers from the outset. I would also just say that these legislative debates tend to characterize public health powers as completely unconstrained. And as we heard from Michelle at the beginning of the session, there are in fact a number of constraints on these powers.
Still, might the outcome of the kind of considered bipartisan process you're talking about be a reduction in powers of state and local public health officials?
Yeah, I think that's one possible outcome, Errol. And if not a reduction, then some kind of reconfiguration of powers. Actually, I know a few county public health officers that would welcome that. But there isn't just a magical win-win here. If we do this kind of review of public health powers, we're going to have to put those powers somewhere. And where will we put them if we peel them away from the executive branch and public health officers? Let's remember how we got these frameworks in the first place. Previous crises taught us that speed and expertise are really, really important in protecting the community. Public health agencies tend to do that pretty well. When the next major hurricane hits, or the big one strikes the Bay Area, or God forbid, there's a biological weapon discharged in St. Louis, will we want the legislature to convene and vote on how to respond to that? Well, and what will we do if they vote along party lines? Will we want the executive branch to engage in rulemaking and public comment in order to decide how to respond? So I think there's a risk of overcorrecting here. I worry that these reforms that we're seeing, these laws, might be too heavily tailored to what people have experienced in this unprecedented pandemic and actually limit our ability to respond to many other kinds of crises in the future.
Great, thanks, Dr. Studdert and Mello. I want to move over now to the audience questions. Thank you so much for those who put questions and answered them and comments on these questions. So please continue to do so. We'll focus on that. I want to start off with one question actually was brought up by Dr. Keeling, a question that we've been getting a lot recently about the FDA approval of the Pfizer vaccine, there's many articles that will say doctors now have the ability to prescribe off-label as they want to. And of course, and Dr. Salas, thank you for noting, not for just been cleared, not for children, the dosing's not sorted out yet, but for the people who have been getting it already, and we know that it's quite safe, can a physician prescribe someone to go get a vaccine that doesn't currently meet the certain guidance that we have right now? Are there legal implications if something goes wrong if they do that?
I can take that one. They can. You know, in the usual case, this wouldn't be a physician prescribing a vaccine. It's much more likely to play out differently on the ground. I think anecdotally, the way this is happening is parents are presenting in pharmacies that don't have a lot of skin in the game and just would like to see people vaccinated, and they just don't ask too many questions. Regardless, whether it's a physician or a pharmacist, there is a potential malpractice cause of action if you give a drug to a group for whom it is not approved or for an indication for whom it is not approved. And certainly, like at the population level, off-label prescribing is known to be associated with a heightened risk for adverse events. But several things would have to happen for this to be like a realistic problem for COVID vaccines. Number one, a kid would have to have an injury that's serious enough to interest a plaintiff's attorney in bringing a claim. Very, very unlikely given the safety profile of the vaccine. Secondly, that injury would have to not be covered by any administrative compensation programs for vaccination in place at the time. And third, they would have to show that it was unreasonable. It was an unreasonable exercise of medical judgment to prescribe it. And if the kid's, 11 years old and 10 months, that's going to be a hard case to make. So I don't see this as a major line of regulation.
I would just add, Errol, that it was pretty clear in the federal announcements of the full approval that this was not an endorsement to prescribe to kids, even if they're 11 3/4, that as you say, the dosing's not figured out, and that's generally not going to be a good idea.
And for the population that's already been approved, so 12 and older adults, we have a lot of physicians who want to prescribe for their patient who technically doesn't meet the level of immunocompromised. Can they legally do that without repercussions? Someone gets an allergic reaction, or is there some sort of issue that we have to worry about?
Again, it's a matter of are you violating any FDA regulations? I think there's not an issue there. There may be other restrictions associated with the allocation of vaccine doses to healthcare organizations. As a matter of contract, there may be promises that it's only going to be delivered in accordance with allocation schemes and approval guidelines, and that would be a different matter.
Okay, thank you. Another question up here, Dr. Klein. Delta Airlines announced today an increase in health insurance premiums of $200 per month for unvaccinated employees starting November 1st. Do you foresee this playing out in the courts? And Tal asks, is this okay under pre-existing provisions for the Affordable Care Act?
Well, that's an interesting one. I haven't read or heard about that. I guess I'd like to consider that in more detail. My initial reaction is that seems to me like something that employers could do. And in fact, there are incentive programs of all kinds that employers implement for health purposes, including related to smoking and exercise and so on. So if it was sort of treated as part of that kind of incentive structure, then I think it would be probably permissible. Again, we have to remember, making decisions about employees based on whether they're vaccinated or not, whether that sounds right or wrong to people, does not automatically implicate federal and state discrimination laws.
Gotcha. I have a comment question from Irene. She says, a telehealth law question for perhaps another grand rounds. Any efforts to facilitate broader licensing for physicians or providers to treat established patients remotely when they are in states or even countries after the pandemic waivers? Many patients in this area likely spend some good time outside of California, and we are learning a lot about how to deliver telehealth. She says thank you as well. Any comments on that?
Yeah, I actually don't know what might be under discussion. I think there is general agreement that we want to continue to permit telehealth to happen, that overall it's gone very well, it's been very helpful. And I do hear a lot that this state-to-state restriction on telehealth is a significant barrier. So it wouldn't surprise me to know that they were considering expanding the regulatory waivers to permit that, but I don't have any specific knowledge about that. I don't know if David's heard anything.
No, just speculation. And I think there is speculation that the state-by-state restrictions will not settle back in the same place that they once were, and that there will be some compacts to come out of this between states that allow that kind of remote treatment, especially in areas where it's kind of needed, like people who live in remote places and so forth.
Great. There was just one comment here, and I want to expand on. Prince asked, which religions prohibit vaccination? What I wanted to build on that, and I've wondered this question too, is when we go to look for exemptions, can we legally look at what the religions have historically done and use that as a reason to accept or decline an exemption?
Yeah, I can take that one. So yes, you can look at what positions the religion has taken on vaccination in the past, what is written into the doctrine or religious texts, a variety of other things that indicate whether the belief is bona fide and associated with that religion. The number of religions that courts have found to have a true, objection to vaccination is pretty narrow. The ones that sort of come up a lot in people's minds, like Orthodox Judaism, actually really not a thing, in that religion. Same for Catholicism, except, in narrow instances where vaccines, are made with fetal tissue. So courts are going to really delve into the religious beliefs. And what they're trying to do is separate out true religious beliefs from the more amorphous and common personal belief exemptions that people previously were able to obtain and now in many states are not, where they just don't believe in vaccines or they believe in the natural healing power of the body. These determinations aren't always black and white, but I think especially in cases where the religion has never objected to childhood vaccines, that's going to be a difficult case to make.
A quick comment here, Dr. Parsonette, interesting information. She just mentions the CDC started off as a branch of the Navy to prevent ships from coming in to bring disease. So she finds it's interesting that they're being regulated. The regulations have been thwarted now. Thanks for that comment, Dr. Parsonette. Dr. Chu asks, can a university mandate in-person student attendance at lectures? Can they insist people come in?
I can't think of a reason why not, unless the person has a medical or religious barrier to doing so, or disability.
Yeah, Michelle and I start a class on Tuesday next week, and it is being offered at Stanford Law School to first-year law students or in-class attendees only. So,
I mean, I think the way courts would examine that issue is to frame it a little differently and say, may universities require vaccination and deny unvaccinated people a remote option? And again, I don't see anything in the law of vaccination exemptions generally that would lead to an unexpected result there.
Concur.
And can I ask, we're at 9:02. Are you okay if we go a few more minutes over?
I'm okay.
Thank you so much. Dr. Wingarden here is asking, are psychiatric or psychosocial concerns considered valid medical objections to requirements for continued employment, school attendance, etc.?
Not to my knowledge. Now, having said that, I'm thinking about how a court would evaluate it. States have, in many cases, been very lax in allowing medical exemptions to stand, and no state more so than our own. When we tightened down our childhood vaccination mandates in 2015, we left huge loopholes that allowed basically any physician, the orthopedist next door, to write you a medical exemption for any reason related to your medical history or anything else. So it really depends on how the law is written sometimes, but courts are looking for recognized contraindications to vaccination, not anxiety.
Yeah, and at some point, Errol, strong emotional responses to the concept of vaccination spill over into sort of philosophical and ethical objections, and that line becomes blurry. And there are many states that have moved away from allowing philosophical objections and stuck only with medical exemptions and religious exemptions.
I just want to clarify one question back to that first one. It sounds like from a legal perspective, there may be ethical dilemmas here, but for a physician to prescribe off-label vaccines, they essentially can. One thing I've learned is that most pharmacists don't even look for prescriptions. They're not really accepting. I've never, really gotten to this situation as an inpatient doctor, but it sounds like from a legal perspective, physicians are allowed with an FDA approval to prescribe this vaccine just like any medication, including off-label.
As a matter of general law, yes. And again, there may be specific terms attached to the vaccine that abridge that.
Yeah, us physicians always want the legal answer simple, but we know it's never the case in reality. So thank you for that. I wanted to ask one more question, and I'm going to ask Dr. Harrington to close this out. Certainly, we've seen countless times doctors, healthcare professionals spreading what the majority of us believe to be misinformation. We've seen it here at Stanford as well. Are there legal implications? This question has been coming up in articles recently. Is there legal implications for a physician going out and saying something that is well understood in the community to be wrong, particularly during this pandemic? And hence, I saw you quoted as in situations like this, people are getting sick because of this happening and perhaps dying. Are there legal ramifications to this, or will there be?
Well, it's hard to it's hard to make that as a malpractice claim, because connecting it to an actual injury and a causal link is really quite difficult. But I think what we are seeing is some of the colleges and medical societies and some of the state medical boards taking a hard look at this, because they have a more general scope of competence and purview on practice, and try to understand whether some of those actions bring the profession into disrepute or fit one of the other categories that they're authorized to police. So, the remedy for that may not be, money damages, but it might be suspension from a professional society or restriction in scope of practice or something like that.
Just put one caveat. I think if it was within the context of an established physician-patient relationship, and your doctor says to you, "Oh, definitely don't get the vaccine. It's incredibly unsafe, and you're at very low risk from COVID." Then you get COVID and get severely ill. Then I think you do have a claim. But what's distinctive versus just a doctor who's on Facebook spreading misinformation is he and I were in a physician-patient relationship.
Yeah.
That's helpful. And thanks, Dr. Salas, for noting that we can notify the board and there may be ramifications through that way. Thanks for that. I'll turn it over. So I just want to thank Dr. Mello and Dr. Studdert for really your time and for all the legal counsel today. It was extremely appreciated, and thanks for the information. I'm going to turn over to Dr. Harrington now to close this out.
Great, thanks, Errol. And as always, masterful moderating job by you. So thank you for your taking us through these questions. Michelle and David, I greatly appreciate, and I think the audience appreciate a different format today. Your mastery of the topic is impressive, and we've all learned a great deal from both your writings, but also listening to you today. There's a little bit of a bittersweet goodbye in my final closing remarks, that you'll be leaving the Department of Medicine, as was noted at the beginning by Errol, as Stanford forms a new Department of Health Policy. So we in the Department of Medicine want you to know that we've appreciated your efforts over the years, and we look forward to continued collaboration with our colleagues in the Department of Health Policy, and always know that you are always welcome in the Department of Medicine family. So thanks for today, and thanks for your many years of work in the department. It's much appreciated.
Thanks. It's not often that lawyers get welcomed into a group of doctors, so we truly appreciate it.
Doctors are notorious for liking their own lawyers. It's the other lawyers we don't like.
Thanks, Bob, and thanks for your leadership.
All right, we'll see everybody next week.